Can you contest a will if someone has dementia? A person can contest a will if they believe the person who executed it was suffering from dementia at that time. However, whether the testator's dementia is going to be sufficient enough to invalidate the will is going to depend on many factors, such as the nature and severity of their dementia symptoms. It's a really complex area, lots of analysis, a lot of fact development. If you have questions, visit our website, rmolawyers.com, to schedule a free consult. Is a will legal if the person executing it has dementia? Yes, a will is legal if the person creating it has dementia, as long as they have sufficient mental awareness to satisfy the relatively low legal threshold known as testamentary capacity. In California, under our probate laws, a person is not mentally competent to make a will if they don't have sufficient mental capacity to understand the following. 1, that they're making a will. 2, the nature and extent of their property. Or 3, their living descendants, spouse, and parents, and those whose interests are going to be affected by that will. As long as the person suffering from dementia has a basic understanding of these concepts, they're likely going to have the mental capacity necessary to create a will. It's important to note here that capacity is only important as of the time that the will is created. Later in capacity isn't going to affect the validity of an earlier created will. Sometimes when there are concerns about whether someone with dementia has the testamentary capacity needed to create a will, with the assistance of their estate planning lawyer, they'll take steps to shore up the validity of the document, such as by having a capacity determination made by a licensed or treating physician, perform a capacity examination or test, or otherwise document or memorialize their abilities and desires to do the planning at issue. Sometimes videotaping a Q&A with the testator can help support the validity of the document they created, but all too often those videos also show that the testator is frail, somewhat incoherent, etc., which in the hands of an experienced probate litigator is only going to serve to help invalidate the will. Can people with dementia contest wills? Yes, people with dementia can contest wills as long as they're an interested party in the will and have the necessary legal capacity to be a party to a lawsuit. However, a person who's been determined to be mentally incompetent due to dementia or another cause can still contest a will through a conservator or a guardian ad litem. Conservators. A conservatorship is a legal process where the court appoints someone, known as the conservator, to make decisions on behalf of an adult who cannot take care of themselves or their finances, the conservatee. Guardians ad litem. In addition to conservators, a guardian ad litem can also represent a mentally incompetent individual in a will contest. A guardian ad litem is an attorney who's appointed by a court to represent the interests of someone who cannot represent their own interests during a legal proceeding. In a will contest or similar legal proceeding, a guardian ad litem can be appointed if the judge determines it's going to be helpful to their case, whether or not the person is also represented by a guardian or conservator. So, for example, if the judge questions whether the appointed conservator is able to act in the best interest of someone with dementia, a separate guardian ad litem can be appointed for those purposes. In these situations, the conservator will still remain part of the case, but the guardian ad litem is going to be responsible and take the opportunity to present the individual's case before the court. Have questions? Give us a call or shoot us an email anytime to schedule a free consult. At RMO, we protect people like you every day. Thanks for watching.